Good evening, everyone. It is 6:30, so I do want to begin for this evening for our May Rights at Night session. And this evening, we are going to be talking about Senate Bill 202. I know many of you have read a lot in the media, varying sides, lots of different information making different claims about this bill. So we want to know, what does it really say and how will that truly impact each of us as a voter? So thank you for being here. And at this time, I will turn it over to Mike McGonigal, our GAE legal counsel, and he will be doing our presentation. Mike?
Okay, thank you, Lisa. I will share my screen. And we want to start at the beginning. Hold on. Hold on, you can see the slides, I assume, but trying to find. Slideshow, okay. From beginning. There we go. Apologize. Well, that's not the beginning. There it is. All right. So, well, good evening, everybody. Looking at Senate Bill 202, want to start a conversation with why it matters to us as educators and as GAE members. Okay. So this is what I want to set out as the goals. So why it matters and why should it matter to GAE? And I want to touch upon how public education and citizen rights fit seamlessly together as one narrative. I think that these are not two narratives: public education on one side, citizen voter rights on the other. I think they are fundamentally linked, and we'll spend a moment looking at that question together. I then want to get into and explore a little bit of how GAE's merger plays an important role in our conversation. I'm assuming most everyone knows what the merger is about. If not, we can address that as we go on. But the merger should not be viewed as an isolated event that took place 52 years ago. It continues to unfold today and continues to inform GAE in terms of SB 202 and citizen rights. And then I spend a little bit of time, because historical context is very, very important. It means a great deal, the context in which SB 202 has arisen in the legislature. And so we'll run through some of that Georgia history to try and give us the broader context in which today the bill was passed. Then we'll go through some of the nuts and bolts of SB 202. It's popularly called and maybe referred to as the Voter Integrity Act of 2021. And then lastly, I want to touch upon what some of the status of the litigation ongoing out there is about. and the difference between the important difference in theories of liability. And we'll be looking at a little bit closely what the disparate impact theory of liability is and why it's important in this discussion. So basically read the slides for yourself. All of this is taken from a fabulous book by a professor of law in South Carolina School of Law, Derek Black. And in it, he very, very persuasively and brings out sort of uncovered ideas and truths that we so often take for granted. And he uncovers them and develops this great story of public education and American citizenship, and why we should be deeply concerned about both and how they form one narrative, not two. And the quote that I took from his book is by one of our founders, and he has many others from others of that period in the 1700s. But Jefferson wrote, "Public education is necessary to prepare citizens to participate effectively and intelligently in our open political system and to preserve freedom and independence." And even though the federal Constitution does not include the word education in the document itself, his argument behind that is that because it was so much taken for granted as how public education was necessary to preserve our rights as free democratic citizens, that they didn't seem it necessary to actually place in writing. But it is very much deeply ingrained in our culture, both political culture and social culture, since we have were founded as a country. His book then goes on to explore the great dynamism that occurred after the Civil War. And he goes through every state constitution of the former Confederate states and illustrates very profoundly how the inclusion of public education in all of the state constitutions after the Civil War has shaped the actual trajectory of our democracy up until the present day. So that is, my point, and the point I think we should all embrace, that why are we in public education? Is because we are fundamentally aligned with citizen rights in creating and preserving our freedom and independence. I just included what our Constitution states, and I underlined the important language that I felt was important, that it is the state's primary obligation for the citizens to have a free public education. And that is enshrined in our Constitution. It speaks of citizens, and it's the primary obligation of the state. It's another discussion, but it doesn't say primary obligation of local boards of education. It says the state of Georgia. And so I fit today's trends in there that informs a larger narrative as to what has been going on in the attacks on public education in the last 20 years or so. You can read it, 1999 charter schools introduced. We've had a declining commitment to adequately fund public education since 2008. We have laws that say you don't have to follow laws, the waivers. Mm-hmm. And then in 2021, there's a very strong correlation between expanding private vouchers as an attack on public education, while at the same time shrinking public citizen voter rights in the same legislative session. I think they are part of the same, I guess, attack on public education. And to the extent that GAE cares for the health and welfare of public education, then we should also care for the health and welfare of citizens, because a primary mission of public education is to prepare citizens to preserve our freedoms. And so as we continue forward, we want to do our best, it seems to me, to be on the right side of history. Now we'll turn and just look at the merger. There is, to me, it's untold or, unacknowledged history of the merger. And we can see a lot of folks who are into GA's history know when the GEA was created, that is, was the newly freed Black African American Association, created in 1866. And then the next organization was the White Exclusionary Education Association. Oh, I got it flipped. The GEA, excuse me, is the association that was white only, and the GTNEA was the newly freed enslaved people. The African Americans formed their associations. And there was the merger in 1970 between those two associations. But in the meantime, there's a tremendous amount of history. As we all know, in 1896, the United States Supreme Court declared that separate but equal was equal. And that was the law of the land at the time. And it took however many years that is until Brown versus Board of Education came along and overruled that holding of Plessy. And of course, Brown said that separate but equal is inherently unequal. And there's a book, again, I'll plug this book. I plugged it many times in presentations, by Professor Vanessa Siddle Walker, who devoted an entire book to one of the founders of GAE, Dr. Horace Tate, uncovering the hidden heroes who fought for justice in schools. And Dr. Tate, as wonderfully illustrated in the book, said that at the time of Brown, that integration was really second class, because the integration that Brown called for was highly resisted by the white powers that be that were in office at the time. And it took that many years, from 54, and we'll see in another slide what occurred in the 1960s, to get that two organizations to merge. Now, in the merger, it's important to realize that in 2020, our organization updated our constitution and bylaws to update our legacy language of exclusion to that of inclusion. And so we looked at what were called ethnic minority guarantees in our constitution and bylaws, and made a decision that they needed to be updated, because at the root of the merger, the root of it is equality of all people. Equality was the driver of the merger. in 1970, and that has to be the GAE's driver today and moving forward. And so I think our mantra, when we look at SB 202, is a couple of questions. Is it inclusionary or is it exclusionary? GAE took a position in 2020 that GAE is committed to being inclusionary and diverse in all of its practices and in its governance. And that's premised on the fundamental belief that all people are created equal. And as we go forward again and we look at SB 202, it helps to reflect on what we are as an association dedicated to inclusivity, not exclusion of either access to public education or access to citizen rights in Georgia. Last question before leaving this slide, I would just throw out there my question that really intrigued me. What if SB 202 was adopted in 1970 or 71, right in that era? I just want folks to ponder what GAE's position would have been at that time. And my belief is we would have been educating members, if not opposed to it. And why that position would be any different than it is today. The historical context of SB 202, as you can see, is significant. You can read that immediately after the Civil War, the right to vote was granted to Black men. 25 were elected to the General Assembly in Georgia, but they were expelled because the powers that be said, yes, you have a right to vote, but it doesn't include the right to hold office. We are also the first state in the Union to enact a poll tax. And by that, we mean paying back taxes before you could vote. And that took 75 years to be repealed. And then if we jump way ahead to the Civil Rights Act of 1964, landmark federal legislation that on many, many fronts began to level the playing field in our march for equality and began to get at the roots of discrimination in employment practices, for example. The Voting Rights Act of 65 and 68, that is also important to understand as it applied to the states that had a history of discrimination against minorities, Black and brown people. And what that meant was anytime Georgia wanted to change its election laws, they had to send the proposed changes to the U.S. Department of Justice for a pre-clearance that it was okay, that you were no longer discriminating against African-American citizens. That was established, again, back in the 60s. I think school desegregation orders, I have unearthed sort of a whole new side business here at unearthing and examining school desegregation orders here in Georgia in legal services efforts in some of our legal cases that we have ongoing with school districts, particularly in South Georgia. It's interesting because so many of these desegregation orders exist, but there is no really good record of their existence. It's very hard to find a clearinghouse that has this information. They have been forgotten, but they are still highly, highly relevant today. For example, in some school districts, they say they've achieved compliance with the desegregation order, when facts on the ground clearly show that the school district is still clearly segregated based on race. There's just a whole other side business that I'm beginning to unearth and appreciate and dig into on behalf of our GA members in certain legal cases. So in 2013, United States Supreme Court said in Shelby County versus Holder that the formula that was arrived at in under the pre-clearance formula to determine whether or not state laws are discriminating against African Americans was no longer required. Supreme Court basically gutted the enforcement provisions of the Voting Rights Act, Section 5, the pre-clearance section. So that was another landmark decision, which means that effectively states are really not, they're not under the federal supervision that they once were required to follow. And it opened the door to, as we see across the country, many voter rights legislation that tend to be exclusionary of citizens and voters rather than inclusionary. And that is a consequence, a direct consequence of the 2013 Shelby versus Holder County decision. And I would argue that is a direct result of or how we got here in 2021, Senate Bill 202, is that we do not, as a state, have to submit this comprehensive election law reform to the Justice Department. So with that, with some historical lessons that I hope you have found interesting, but also can appreciate why it matters in the historical context, both for us as an organization, its connections of public education and voter rights, as well as the history of the merger, is still with us today, and it will continue to unfold as we move into the future. So we'll move into some of the nuts and bolts of SB 202. So in my research for looking at SB 202, I had to get a little more up to speed on what the state election board does. And I found the phrase that the state board is responsible for maintaining the legality and purity in all primaries and elections. And I suppose there's ways to define what purity means, but when I read that, I was absolutely stunned, because to me that means racial purity. That's how it came across to me. So I just leave that there. Seems to me that's their goal, to make sure our election laws and our elections are pure. Recently in Texas, there was an attempt, maybe they got it through, to introduce into their state election law the same or similar language. And of course, a firestorm of criticism erupted over the term purity of elections, because it truly, for many people, speaks to exclusion and racial purity. So the stated goals of SB 202, there's two main ones: restoring voter confidence and to ensure election integrity. And so as we go through, we can look at some of the public statements that have been made in the record prior to SB 202. What is prior to SB 202, Georgia had just conducted the safest and most secure election in our history, and it was the gold standard. So it seems right to question restore what confidence that we had before SB 202 and what happened now that our confidence is shaken. You might ask, whose confidence is shaken? It's also to restore integrity. Well, again, before SB 202, it was stated by state officials, Secretary of State to be exact, that SB 202 was a reactionary campaign that could have been avoided. And the avoidance he was referring to were lawsuits, meritless lawsuits that were filed in Georgia on behalf of the losing presidential candidate. So those are the goals. As we go through some more slides, keep in mind, are we talking about inclusivity or exclusion? And who is being included and who is being excluded? So one of the first points of SB 202 is that the drop boxes are now confined to early voting sites. Is that expanding voter access, or is it contracting voter access? Again, in 2020, there was no evidence of voter fraud based on the number of drop boxes that we had available for citizens. Some of these tighter restrictions are that the drop boxes have to be inside of the polling place where you vote, which if you're going inside to vote, why put the drop box there? But just ask yourself the question. It says that they must be under constant surveillance. Well, in 2020, the drop boxes were being monitored by video cameras to ensure there was no tampering. But now it's been codified into law. They also put a cap on the number of drop boxes per active 1 to 100,000 per active registered voters. And so you'll see what the impact is in Metro Atlanta, that it means that Metro Atlanta had 111 drop boxes and will drop down to 23. Well, again, you can look at the slide and see the impact that has on the metro area. Heavy concentration of African American minority voters. 2/3 of all the absentee ballots went to the winner of the presidential election. Ballots that were placed inside of drop boxes were reviewed for fraud, looking at the signatures on ballots. There were 15,000 such ballots reviewed in Cobb County, and not one was found to be fraudulent. So you have to ask yourself, why? And are we being inclusive, or are we excluding people access to fundamental right of voting? So I can't hear you.
Sorry, I have a question about that because it said to 1 per 100,000 or the number of early voting places. So if a county has 300,000 people, but only one early voting place, does that mean they can only have one drop box?
Could you say that again?
Okay, so it said 1 per 100,000 or the number of early voting places.
Okay, right.
So if a county has 300,000 voters, but only one place for early voting, then that one early voting place will only have one drop box for the whole county.
If that's what they decide, yes.
Okay.
Yes. They could decide that. It's a great point. ID. And I guess the question I have is, you know, and I know Lisa, you may want to chime in with a story, but this is going to impact people who are already economically disadvantaged to obtain the free state ID. People have to go through all sorts of hoops and hurdles to obtain that ostensibly free state ID, and you have to do it twice. You have to use the driver's license when both requesting an absentee ballot and when returning it. Again, it seems to set up a two-tier system of voting access based on how much money you have. If you're poor and you're working more than one job, and you don't have a driver's license, you're relying on public transportation, you're going to have to get an ID, a free ID. And you have to figure out how to go get it. You're going to have to figure out how to get off work, go to voter registration in your county, spend half a day in line, and then maybe at the end of the wait, you're going to get a free ID. Well, that experience, I don't have to experience anything remotely to that. In this instance, it places another disadvantage on disadvantaged people based on their income. And again, are we being inclusive or exclusive? And who is being affected by this particular provision? Anything, Lisa, or do you want
to? The other thing I was going to say about this is when you have to provide a copy, I know many of us as educators, we have access to copy machines and printers. It's not a problem for us. But in a rural part of the state, somebody that doesn't have a copy machine at home, may not have a computer, there are no FedEx stores in their town where they can go in and even pay to get a copy of anything. So this is not only our disadvantaged financially, but also our more rural voters that don't have ready access to copy machines.
Right. I don't live that experience at all. I have all the conveniences that I could possibly want and imagine. But for other Georgians, that's just not reality. That is not reality. So it also, 202 changes voting hours. Sunday voting remains optional, which means you don't have to have Sunday voting if you don't want it. So rather than expand the voting franchise and the access to voter rights, the legislature is just making Sunday voting an option. Now, rural Georgia seems to gain an extra Saturday voting because Saturday voting was, as I understand it, an option. But now it's going to be required to have an extra Saturday of early voting in many areas that they didn't have before. It also significantly reduces the time between the general election and the runoff election from 9 to 4 weeks. So we might ask ourselves, compressing the time, does that restore our confidence in the election as one of the stated goals of SB 202? Or is it going to weaken confidence?
I'm going to talk about our students on this one, Mike. When we had the runoff in January, our students who turned 18 the day after the general election in November, we registered them to vote, and they were then eligible to vote in the runoff. So anyone that turned 18 in those 9 weeks was eligible to register to vote, and then they were voting in the runoff. This will eliminate the opportunity to register those young people and allow them to vote for the first time in the first election after they turn 18.
Mhm. Mhm. So this slide, it just gets to the data on the number of absentees in the primary, the general, and the runoff. And it just is just more data to show that the change in early voting hours, you know, it favors one group and disfavors another group.
Okay, I wanted to ask a question about that one too, because I know it says that 9 to 5 is now the standard early voting hours.
Right.
So I would hazard to say that for the vast majority of our members, 9 to 5, they are in a school doing their job, or at least 9 to 3. And we all know how often it is you can leave right at when you're supposed to. So that is going to mean that most people are going to have to either take time off work if they want to go early vote, or the early voting is not going to be available to them.
Yeah, and it's interesting that the statute, it codifies 9 to 5.
Right.
And it didn't do that previously. And again, is it placing a burden on people? Is it expanding access to rights, or is it not? So one of the areas that it got a lot of attention, and there seems to be misunderstanding about the criminalization of food and water. The statute, SB 202, the bill, I mean, it does state no person shall, no person. There seems to be something out there about organizations, and it really doesn't apply to me or you or anybody else if we see fit to give food and water to voters within certain parameters. I think it's within 150 feet of the polling place. It does criminalize it. When you look at it's section 34 of SB 202, it amends this other statute 21-2-414 that says that when the penalty for violating the statute are misdemeanors, And then when you cross-reference a misdemeanor to the criminal code 17-10-3, you'll see where misdemeanors are defined of fines up to $1,000 and up to a year in jail. So those are, I mean, those are just facts. And of course, who is impacted? It's where there are long lines of voters that we see, you know, in metro area and other urban areas. And I added this PolitiFact. You can look up PolitiFact. The question they examined was SB 202 does not criminalize food and water. And you can look it up for a long list of reasons that PolitiFact rated that question mostly false. And the only reason that they didn't say like pants on fire type false is because the SB 202 says that the poll workers can set up self-serving water receptacles outside of the polling station. So they'll have a self-serving water receptacle outside the polling station, which is very not a good way to set up to increase access to the right to vote. Was there anything there, Lisa? Or is this sort of a big shiny ball that?
I think it's the big shiny ball. And I don't know if many of you have had that experience of standing in line multiple hours to vote. I have, on 2 separate occasions, stood in line for more than 4 hours. And I think I'm hopeful that this won't be a problem for people, because if they've stood in line for 3 hours, I'm hopeful they will remain determined that they are not going to leave the line. Or, as what happened when I was in those long lines, people would hold each other's space and allow them to go get what they need and come back and get back in their space.
Mm-hmm. So it imposes earlier absentee ballot deadlines. Of course, 2020 saw a huge amount of absentee ballots cast, and it made it easier, quite frankly, to request them. But now that's virtually been cut in more than half, from 180 days before the election to 78 days. And it then shrinks the amount of time that you get to return the ballot before election day. So again, as we go through, are we expanding rights or are we contracting rights? And we experience the same in public education, where our rights have been shrinking and contracting by an ideology to privatize public education. And at the same time, we are privatizing a public right to vote at the same time. It's one narrative. So it just so happens that one county in the state, Fulton, brought portable polling stations to voters. 112,000 cast mobile ballots in Fulton. Those are banned unless the governor, whoever's the governor at the time, declares an emergency based on power outages or storms, things of that nature. But you clearly have to ask yourself, are we expanding the opportunities to vote? for people during the day. It's kind of in the pandemic. When people weren't going to get the vaccine, we were taking the vaccine to the people to make it as easy as possible to get the vaccine if you chose the vaccine. This is the same thing. We were taking polling places to people to make it easier to cast a ballot. That right is now gone. Well, this is another interesting provision that if you say, for example, you move and you show up at your former precinct and you want to vote. Well, used to be you could vote, and it was called a provisional ballot that would be examined and scrutinized to determine if you are a registered voter. And then even though you were in the wrong precinct, they counted the ballot. Well, now that's been taken away. 3,357 provisional ballots that counted in 2020 will no longer be valid.
And this is another one, Mike, that I think we need to think about a little bit more. It's not just that the voter moved. I live in Gwinnett. Gwinnett opens new precincts and moves the precincts to a new place all the time. So if they've moved where I am supposed to vote and I get there I don't have time to get to the new place, I now can't vote because I didn't know that they moved my location to a new location.
Yes, Lisa, that is correct.
Okay.
But I didn't know that they changed up those polling places without really making it widely known.
Yep. It
Okay.
happens all the time.
Oh, I guess the next is a graph.
Okay.
So that just breaks down where those provisional ballots that were cast in the wrong precinct. But I like your point about you show up where you always thought it was, and they moved it on you at no fault of your own. And if you don't hustle and get to the right place, then it's possible your vote's not going to count. So in the run up to 2020, we had many, I don't know how many, but nonprofit organizations. I know many people everybody who lives here probably got your mailbox was full of requests to apply for absentee ballots from nonprofit organizations. That's no longer the case. In fact, that's actually carries a civil fine, a punishment, or a poll tax. That if a voter has received an absentee ballot or has requested one, then it's illegal for anybody else to send you another application to request an absentee ballot. And so that opportunity again for access has been reduced under SB 202 and really attaches a fine to something that would be so basic as reminding voters of a right to vote by absentee ballot is now being punished. And it actually prohibits state and local governments from engaging in that practice as well, not just nonprofit organizations. So the government that's responsible for ensuring elections are now going to be punished for reminding voters that they can request an absentee ballot if they've already requested one.
So we as an organization
Mm,
sent absentee ballots in our magazine to our members, request forms. So if we put that in our magazine and somebody's already requested an absentee ballot, we have violated this law.
$100 fine, Lisa, for, so I don't know if we have a line item devoted to,
No,
no?
no,
Well, I guess we'll have to figure that out then.
right.
Roll Tide. Roll
Well, now
Tide.
this is interesting as well. Unlimited challenges to voter eligibility. Unlimited means unlimited. And I can do it anonymously. If I go to any county you want to name and get their voter registration rolls, you can challenge the voter registration rolls for that county, and it can be done anonymously. And one of these slides, the investigations are going to be conducted by the State Attorney General's office, which is the law enforcement arm of Georgia. You know, we'll just be expanding meritless challenge, unlimited meritless challenges. In fact, it's already been attempted in this state by a Texas group, based on a suspicion or a hunch that people might have moved. And you know, normally that's something, a suspicion and a hunch doesn't provide a legal basis for an investigation until SB 202. And it'll bear watching what procedures the Attorney General's office either has in place or is going to have in place for determining the validity of an anonymous complaint. That part remains to be seen, but what we know for sure, the challenges are unlimited, and those who have a lot of money will have more advantage over those who don't. Let me see. Oh, this is some of the oversight about long lines leading to voting sites and more confusion. So the idea here is the polling place has to measure the wait times at least 3 times a day. And if you're waiting more than an hour, you have to reduce the number of voters to 2,000 in that precinct. So we're going to have a lot of measuring of wait times. And then we're going to have to figure out where are we going to set up these new polling places? How are we going to tell people how to get there? Like Lisa said, you know, they don't have, I don't think this tells you, codifies that they have to tell us where they're changing the precincts. We just know that they can do that. So the upshot that I take away is that voters can still report to the old precinct where the provisional ballot will not be counted. The catch is except after 5 p.m. on voting day. So if Lisa's been waiting in line for 3 hours and then it turns out she's has been assigned to a new precinct, it has to be, she's got to get over there quick. Election results have to be reported more quickly. Well, you can read the slide for yourself, but you have to ask, does speed necessarily contribute to voter confidence? Because one of the goals of the act is to restore voter confidence. So if we speed up reporting, you have to ask, tabulating votes on a more expedited basis, are there going to possibly be more mistakes in this process? I can't imagine. I can't imagine that happening.
I can't imagine requiring that counting cannot stop for any reason is going to make things more accurate, meaning you're telling people, I know the typical elections worker is there at 6 a.m. on election day, and you are going to be here until everything is done, period, no matter what. I think after, probably around 10, 11 o'clock that night, they're going to be very tired, and yeah, mistakes are going to happen.
Yeah, this kind of reminds me of teachers not having a right to a potty break. And it's, oh, this special paper. The SB 202 mandates special paper. I'm not sure of the justification or rationale. We do know that it's going to double the cost of regular paper by over $1 million if the turnout's like November 2020. And I think the turnout will be substantial in 2022. So your ballots are now public records. They're going to be digitized, and how you voted is still confidential, but they're going to be digitized, and I can have access to that as a citizen. And for me, one of the questions, is what is the security of that system? If they're all digital and they're stored on memory cards, how secure is that? Number one. And I suppose that plays into the challenges that we'll see if all I have to do is click a button and ask for the digital images of paper ballots. And apparently I can challenge voter registration just with a few clicks. Poll watchers, that's a good thing. Poll watchers are a good thing. They'll have more access to ballot counting. Concern is the statute doesn't define acceptable parameters or how close a poll watcher can be to the counting process. And so it leaves open the possibility, if not increasing the possibility, because we have no statutory definitions of voter intimidation and harassment by poll watchers. And I know statute says they have to have training, but once they get in there, what's the enforcement? How close is too close? What are the parameters? Well, SB 202 doesn't tell us that. It just leaves it open-ended. So the state takeover of county election boards, again, there can be a performance audit requested by, I want to say it's any citizen or no, excuse me, a county commission or a state legislator who resides in a county. The county can request a performance audit. And if they don't pass the audit, then the state election board can just simply take it over, hire and fire staff, let the state decide on local voting locations and manage absentee ballots. The law forbids local governments from hiring lawyers to defend themselves in front of the audit committee of the state. So they're going to have to get very creative, or they're just on their own. And this will have an impact, as we've seen by virtue of earlier slides, in the metro area, Fulton County, City of Atlanta, where we have, there are long lines. People want to vote. They're entitled to vote. So there's going to be long lines, and it's going to take a while to count those ballots as well. So are we being inclusive as we look at SB 202? Is it in line with GA's goals of inclusivity and taking a stand against exclusivity?
Mike,
Yep.
Sharon Doe, our vice president, put this in the chat, and I think this is a wonderful example. In 2016, we had the Opportunity School District that would allow the school to take over from our local school boards, our public schools. And this is the same thing. Instead of allowing the school to be taken over, it's allowing our right to vote to be taken over by the state. And I think we all know that the voters in the state of Georgia wanted their schools to remain local. I would think we also, voters across the state, want their voting rights to remain local.
Yep, that's a great point. That's a great point. State takeover. So the law enforcement hotline, I alluded to it earlier. Unlimited number of challenges being conducted by the state attorney general's office now. That was quite a concern. Well, that's quite a concern. Are we going to be going on wild goose chases? I guess the answer is yes. The answer is yes on that.
And so if
Yeah.
it's an anonymous complaint, are they going to go to somebody and say, somebody said you intimidated somebody in line, and you have no idea who you have how do they defend themselves when they have no idea who they supposedly harassed or intimidated?
Right, right. I'm called into the principal's office and a parent complained on me, and no, I won't tell you the name of the parent, but this is what the parent said. How do you defend yourself in a situation like that? Nonprofit organizations are curtailed from providing financial assistance. So 2020, there's lots of nonprofit money going into paying for staffing, PPE, voter outreach, and the donation of the State Farm arena, for early voting could be eliminated as a result of SB 202. And again, it would seem to have a greater impact right here in Atlanta, where there are large numbers of African-American voters that favored the winner of the presidential election. So we're going to begin to wrap up. I just wanted to look at real briefly, there's seven different lawsuits that have been filed against the implementation of SB 202, and they take various pieces of it and then hone in on those pieces. So there's two ways of going at a discriminatory law. One would be Mike's motive. What is my motive? Do I have a motive or an intent to discriminate against another individual? That's intentional discrimination, and that's what we do in legal services when we're going after a district on employment discrimination. We have to show the decision maker's intent to discriminate. So the creators of SB 202, what was their intention? What was going on in their minds? Well, that's not really the relevant question in the litigation. It doesn't have to be what their subjective intentions or motivations were in voting for SB 202 or signing SB 202. The cases look to what is the impact on voters. It asks a very simple question. Does a facially neutral law have a discriminatory impact on a protected class? And that's it. The courts are going to be guided by three different questions. They don't look to the motive, they look at the impact. Does it have an adverse impact that falls disproportionately on a race, color, or national origin group? What's the impact on those groups? Race, color, national origin. Two, if it does the record establish a substantial, legitimate justification for the policy or practice? Well, one of the questions is going to be in the record. The last election was the gold standard. It was the safest, most secure election in Georgia voter history. And then the last question a court will look at, is there an alternative that would achieve the same legitimate objection, but with less of a discriminatory effect? And so we'll await what the courts have to say and rule on these. Right now there's seven different lawsuits, but they're going to be looking at the impact, not the motivation, subjective intent or motivation of those who voted for it, but they're going to be looking at the impact that it has on race, color, national origin, and was there some other way, legitimate way, to achieve that? And so it's put into the court system now to resolve those questions. I really have come to the end, and of course I always want to plug legal services. I'm preaching to the choir, but as General Counsel, Legal Services Director, I just want you all to be reminded of the excellent benefits that we have in legal services when you're talking with members who might be thinking of leaving, or talking with non-members, potential members who wish to join us. So we're stronger together, and of course legal is there to support you. And we thank you for your membership and your time this evening.
Thank you, Mike. I think we all learned a lot. And if anyone has, we haven't had any questions put in the chat so far, but if anyone has questions, certainly I'm not going to be able to answer, but I think Mike would be able to answer them. And I'll give you a few seconds to see if anyone does have a question that they want to type in the chat. I do want to thank each of you for being with us this evening, and we will have the recording available on our GAE YouTube channel for you to share, and for you to share with the other members that you know, because public education is a public good, and public education can only remain if we have voters who are able to vote and ensure that we keep public education public. So I haven't seen any questions yet. So thank you all very much for joining us this evening. And thank you for being a member of GAE. And you all have a great evening.